is the situation of people who have possessed bump stocks between the time of the ATF's new rule and the present day, or between the time of the new rule and the Fifth Circuit decision, can they be prosecuted?
I think probably yes, unless they had gotten some judicial relief from the rule. The rule has not been enjoined. It hasn't been vacated writ large. So I think the government has made clear that this is what we think the statute means. I'll say in practice—
Isn't that disturbing? People in the Fifth Circuit who've been possessing firearms since the beginning of 2023, let's say they are aware of the Fifth Circuit's decision that they can be criminally prosecuted for doing something that the Court of Appeals that governs their territory has said is not illegal?
Well, let me give a practical answer and then a doctrinal answer. I think practically, I'm not aware of a lot of these prosecutions being brought because we recognize that there is some legal uncertainty. But I think doctrinally, that could happen all the time, Justice Alito. Circuits disagree about what a criminal law means, and someone might, in reliance on their circuit precedent, do something that they think is lawful under circuit precedent that other circuits disagree with, that the government disagrees with, and that this court ultimately holds is covered by the statute.
When we speak of the function of an inanimate object, don't we normally look at what that inanimate object does? So why isn't the function of a trigger to release the hammer? Let's look at the M16, the AR-15. The function of why isn't the function of the trigger to release the hammer from the sear so that the hammer can swing forward and strike? Isn't that the most straightforward interpretation of this?
I don't think so, and I think even if you thought that was true just looking at the text alone, the three indications that we've talked about, the contemporaneous usage by the President of the NRA and others, the application to other kinds of triggers, which everybody agrees are covered but which don't function by moving the hammer, and then also just evasion. I mean, I talked about some of them, but one of the devices that the Fifth Circuit has held is permissible, or I'm sorry, a district court in the Fifth Circuit has held is permissible, and the Fifth Circuit has declined to stay, is something called a forced reset trigger. And with a forced reset trigger, the ATF tested it, zip-tied the trigger back, and the gun shot multiple bullets. What the district court said is that under my friend's interpretation, there are multiple functions of the trigger because the trigger is wiggling back and forth imperceptibly and releasing the hammer separately each time, and so it's not a machine gun. And I think it's just not reasonable to read the statute that opens it up to that sort of evasion, and we're seeing concrete evidence of that evasion in the Fifth Circuit.
Thank you.